Okay, so picture this. You've got an old abandoned farmhouse that keeps getting broken into. The owners were totally fed up, set a trap to protect what's theirs. A trespasser breaks in, gets hurt, and then he sues the owners. Sounds like a pretty open and shut case, right? Well, you might want to buckle up because you are in for a huge surprise.
So what happened? The jury gave the guy who broke in, who, by the way, had already pled guilty to theft, $30,000. And get this, in today's money, that's nearly $250,000. Yeah. The verdict sent shockwaves across the country and made this one of the most talked about, most controversial cases in the history of property law.
So that's the big question here, isn't it? How on earth could a burglar sue the homeowner and actually win? Well, the answer pulls back the curtain on a really fundamental principle of the law, one that values something way more than just property. Let's dive in and unpack the very strange and fascinating case of Katko versus Briney.
To really get what the court was thinking, you gotta know the backstory. So, meet Edward and Bertha Briney. They had this old farmhouse in Iowa. They weren't living there anymore, but they used it for storage. Family heirlooms, antiques, that kind of thing. But they had this one major headache. People kept breaking in.
And this wasn't a new problem. We're talking about more than a decade of frustration building up. They did everything you'd expect, boarded up the windows, slapped no trespassing signs all over the place. But none of it worked. The break-ins just kept happening. So by 1967, they were just done. They felt like they had to do something more extreme. And you can really feel his frustration in his own words. This wasn't some evil guy trying to hurt people for fun. He was just a homeowner who was completely at his wit's end. You can hear it, right? He felt tormented. He just wanted to stop.
So what did he do? He rigged up this trap. It was a 20-gauge shotgun tied to a bedpost with a wire running from the trigger to a doorknob. Now pay attention, because a couple of details here are super important for how this all plays out. First, his wife talked him into aiming it low to hit an intruder's legs, not to kill them. But second, and this is the real kicker, he didn't put up a single sign, no warning at all that a shotgun was waiting inside.
So, fast forward to July 16, 1967. A guy named Marvin Katko breaks in. He wasn't after a big score. He was looking for old bottles and jars, what the law calls petty larceny. He opens that bedroom door, and bam, the trap goes off, and his leg gets torn up pretty bad. And then, after he gets out of the hospital, Katko does something nobody saw coming. He sues the Briney. And you know what? The local jury sided with him. They gave him that 30 grand. Of course, the Brineys were floored. They argued they had every right to protect their property. They appealed, and the case climbed all the way up to the Iowa Supreme Court. And the whole thing boiled down to one single fundamental legal idea.
And that big idea is called justifiable force. It's pretty straightforward, really. The law says, sure, you can defend your stuff, but the way you defend it has to be proportional to the threat. You can't use a bazooka to stop someone from stepping on your lawn. The force would be totally, completely out of whack with the offense.
And this right here is the heart of it. This quote the court used pretty much says it all. When it comes down to it, the law has to make a choice, and it chooses human life and safety over things, every single time. You just can't use force that's likely to cause serious harm or even death just to protect stuff from a simple trespass.
This right here was basically the final nail in the coffin for the Briney's case. The court posed a really simple thought experiment. Imagine Mr. Briney was actually there in the room when Katko broke in. Could he have legally shot Katko in the legs for trying to steal some old jars? And the answer is a hard no. Why? Because the threat was just a property, not to a person. So if he couldn't do it himself, in person, he sure as heck couldn't build a machine to do it for him. Okay, so the main rule seems simple enough. You can't use deadly force to protect property. But, the law is never that black and white. It's all about the details, the gray areas. So let's play a little game of what if and look at some other real court cases to see how this principle actually works in practice. All right, first up, the big one. What if the owner is actually there? Does that change the whole equation? What if we're not talking about an empty house anymore, but a full-blown robbery happening right now?
So let's check out this other case, Wright versus Hafke. Here you have a store owner who gets assaulted during a robbery. As the bad guys are fleeing, he shoots one of them, and the court said that was justified. So what gives? Why is this different? Well, because the threat completely changed. It wasn't just about stolen property anymore. This was a robbery, a violent felony. It was a direct threat to the owner's life. Suddenly, using that level of force became proportional.
Okay, cool. What about this one? A shotgun trap is just a dumb machine, right? It can't think. But what about a watchdog?
Is that a different story in the eyes of the law? And the answer is yes. It is totally different. And it all comes down to one word: discretion. Think about it. That shotgun trap will shoot anyone who opens the door. A burglar, sure, but also a firefighter or a kid who gets lost. A dog, on the other hand, can size up the situation. It can just bark. It can warn someone off. It might not attack at all. It's not, as the court called the gun trap, an indiscriminate man-killing device. So the situations just aren't the same.
All right, let's get even weirder with it. Let's take people out of the picture entirely. What happens when it's property versus property? Like, say, your chickens versus the neighbor's dog that keeps sneaking into your yard.
Now this is where that whole proportionality thing gets super specific and really interesting. In one case, a guy was allowed to shoot a dog that kept eating his chicken eggs, but, and this is a big but, it was only okay because he tried everything else first to solve the problem. Then you have another case where shooting a dog attacking a goat was found to be okay, but the court added this little twist. They said the outcome might have been different if the values of the animals were greatly disproportionate. Meaning, yeah, the actual dollar value of the property at risk can come into play.
So when you step back and look at all of this, from shotgun traps to robberies to dogs eating eggs, one big idea starts to shine through. It's the one common thread that ties all these wild, seemingly contradictory rulings together. And it's this: context is everything. The law is always going to ask, is the force proportional to the threat? Are we protecting a person or just stuff? Is there someone there who can actually make a judgment call, or is it an automatic, indiscriminate trap? So yeah, I get it. The Katko decision might feel wrong in your gut, but it's the totally logical result of a legal system that, when forced to choose, will always say that a human life, even the life of someone breaking the law, is more valuable than some old jars in an empty house.
And this all brings us right back to today. I mean, the Briney shotgun trap sounds almost primitive now, right? We've got smart cameras, security drones, all kinds of automated defenses. The tech is way more advanced, but the fundamental question from this old case is more relevant than ever. Where exactly do we draw that line between just protecting our property and using a prohibited, dangerous force? It's definitely something to think about.